All right, welcome back to the Pain and Wellness Hour, sponsored by Weineman Pain and Wellness, serious doctors for serious injuries. So we're continuing our conversation, really captivating conversation. We're really enjoying it with David Zealous and Brandon Swartz. And so we're continuing a little bit about what we were talking about before we went to the break. We're talking about, sometimes you're dealing with a client. But criminal laws, it's obviously very interesting. But one of the things from my perspective is that, and you just mentioned it, we're in America, you're innocent until proven guilty. And that concept sometimes gets lost, specifically in the media. Obviously, I get it, we're selling newspapers, but at the end of the day, you have a totally different perspective. How often do you think, when at the onset of something, you have to deal with that situation where the momentum is coming against you, and this individual is stating their innocence, and even so, they're innocent until proven guilty.
It happens more than you think. I would venture to say that every high-profile case, the defense is already starting with a wall set up in which every juror, every judge has already made up their mind.
And that's a big part about the jury pool.
Yeah. And from year to year, it differs as to what everybody, what the hot crime is. Right now, if you're a heroin dealer, you're not getting a fair trial.
Right.
It's just right out of the chute. You're not going to get a fair trial. The judge is against you. The prosecutor is ready to send you to the moon. And the jurors, they all feel like, every heroin dealer is dealing in death. So therefore, hang them all.
Right.
And what, as an attorney representing somebody who, is accused of the crime, you have to bring everybody back to reality and try to emphasize the fact that, he is innocent until proven guilty. And they can't prove their case because they don't have the evidence. The question comes up, especially with heroin dealers, if there are no drugs and there's no money, and yet you have 3 or 4 heroin users say, oh, yeah, he's the guy who sold me the heroin. Is that enough to really put somebody away in jail?
Yeah, Joe, it's interesting what David's alluding to. So my whole career since I graduated law school has all been focused on one aspect of personal injury or another. Everything that we do represents somebody that sustained some sort of injury, whether it was a motor vehicle accident, a victim of medical neglect, etc. However, when I was in law school, I had a job and I worked at the death penalty clinic, the death penalty defense clinic in Philadelphia. It was started as a program in Philadelphia. It was ultimately merged into the federal court program. But you would be stunned, the files that we would read there. These are death penalty cases. I remember reading a case one time. The whole trial, from beginning to end, was about 3 days in a death penalty case. 3 days. There's no DNA evidence and no eyewitness testimony. Mm-hmm. So you would say to yourself, how in the world could anybody get convicted of a crime and given the death penalty when there's no DNA evidence and no eyewitness testimony? So when we're defending this person, you dig a little deeper, and here's what you learn. You learn that the crime had gone unsolved for a long period of time. So you had a high-profile victim at the time and a crime that went unsolved. And what you have is tremendous pressure building on the police to try to find somebody to be the one that they're going to prosecute in that case. And when there's so much pressure on that side, and you're ultimately the one that gets accused of that crime, you need to have somebody defending you that understands what that pressure was and can see through that pressure and sort of figure out why they may have chosen to arrest the person that they did, and why they may have done that without having had all of the evidence necessary to do that.
And when I listen to what you just said, it brings up 2 thoughts. Number one, you're talking about, with the new district attorney coming in, Larry Krasner. One of the things he's talking about is quotas that the police department have, and that the DA's office, that creates an unfair type of situation and a pressure that creates a different environment. And then you talk about the amount, money, simply money. If an individual doesn't have the money, I could not respect anybody more than I do injury attorneys that are putting their time out for free. And they have to win to get paid, but at least there's somewhere to get paid, and that gives you incentive to win. In a criminal attorney's situation, you don't have anywhere else to make a living. You have to charge the client, and your time is money. So at the end of the day, the finances also jump into that particular situation. Let's talk about the police department and the DA's office and the pressure, like Brandon said, first. How is the system set up so that it creates something that often a defendant, is in a terrible situation because of it?
Well, I think the influence of the media can't be understated, because the media is a driving force in putting pressure on law enforcement, putting pressure on the DA's office about solving a crime. You have some of these horrendous crimes, and if they're not solved right away, then it's like a drumbeat.
Right.
What are you doing today? What's going on today? How are you solving this? If you remember, it wasn't that long ago in Bucks County, there were the missing kids.
Right, exactly.
And I mean, the media came from all over the country, and they wanted to see this case solved. And ultimately, the district attorney, whether you like it or not, gave up the death penalty in order to find the last body.
The body, right.
Now, some people looked at that like, what's he caving in for? Other people looked at it, well, it was the right thing to do because that family needed to put their child to rest.
Exactly.
David, I have a quick question. So you had mentioned media and how that, media exposure can weigh against or for a case depending on what it is. How about social media? Because I would find that, and I would think that both of you as attorneys, social media can play a big part in a case. If somebody picks up a video or somebody has something that shows evidence that they were guilty or not guilty, how does that play into it? And how can you, what would you tell a client too, as far as social media goes? Stay off it, stay on it?
Well, as far as the client is concerned, anything you say can and will be used against you, whether you're talking to a police officer or whether you're talking on social media. Mm-hmm. Somewhere, somehow, it's going to be used against you. So do not use social media. Mm-hmm. On the other hand, social media, there are a few things in the recent past that has helped criminal defense cases, at least from my experience. One is social media, mm-hmm. because victims often will go on there and contradict what they told the police, and then you can use that against them. And then the other one would be police dash cams, where the police are videotaping. And these videotapes, every one that I've seen so far, either it convinces the client that he has to plead guilty because it's clear as day that you were under the influence due to that tape, or it convinces the attorney, like, you have a real case here. I don't see what the basis of the stop was. I don't see what the basis for having you do a field sobriety test or even give your blood was. Right. So those two media type of evidence have been very helpful, I think, to the defense.
Yeah, I mean, I think there's no doubt that we experienced the same thing. I mean, my partner and I, we lead seminars talking about both social media and using today's technology for what's available. So, for instance, in our practice, the very first letter that goes out to every one of our clients is stay off of social media completely during the course of your claim. So as far as social media, to us, it's not even a close call. There's no circumstance where social media can help you while you're in the middle of prosecuting your own injury claim. Mm-hmm. But then separately, what we have experienced so much over the years that it's now become stunning is that there is so much digital video running wherever it may be, that we now probably have in our office anywhere between 20 and 50 cases where we can actually find the video evidence of the actual event event itself. And use that in prosecuting in their case. And there is nothing more breathtaking than watching a catastrophic injury on video. Yeah. It's one thing to describe it, but it's another thing to watch it. The classic example that I always give to the attorneys when I talk in my office, you remember the Ray Rice incident that happened with the NFL?
Absolutely.
So here's what happened with the Ray Rice incident in the NFL. They had the exact facts of what happened in the Ray Rice case. But when it was verbalized to them, it was a 2-game suspension.
Right, 2-game suspension.
When people actually saw the video of what happened, it went from a 2-game to suspension to essentially a career-ending event because of what happened. So it went from 2 games to career ending, and that was the difference between trying to verbalize something to somebody and them actually being able to see the video. So Marla, what you're alluding to there is exactly what we do here, and why it's so important to have these things.
Interesting. Also, talk about the media in general. I've had several situations where I've seen individuals where the media's come down on them. I even on my radio show, I did an intro to a show about the unfairness that was going on with the media. There was 4 major stories about an individual. Total unbelievable. So I jumped on there, okay? And it wasn't about me, so it was easy to do it. But an individual who will remain nameless, because I am friends with him, said to me one time, it's tough to pick a fight. Like, so somebody's getting their brains beat out in the media. This individual is a member of the media, and he said, well, just remember, never pick a fight with somebody who buys ink by the barrel. In other words, you're sitting there and you want to come back and say, listen, innocent until proven guilty here, and I am innocent and blah, blah. And, oh, by the way, go ahead, Mara.
Yeah, I just wanted to ask you real quick, just kind of tail ending off of what we were speaking of. Have you ever been caught by surprise in a case where you think all your ducks are in order, and then somebody shows you something that you're just like, looking at your client, like, what the hell?
So I would answer that question yes and no. Mm-hmm. So in our cases, we have what we call the discovery period. So there's really supposed to be no surprises, insofar that everything has been turned over. So for the most part, we're not caught by surprise in the cases, but it never fails that every 3, 4, 5 months, just out of nowhere, somebody comes forward and said, oh, yeah, I happened to be driving by at the area, and I caught video of what happened afterwards, or something along those lines. Yeah, so for sure, there's never any circumstance where you involved with the law that you think something's going to go on a perfect path, and it ends up going on that perfect path. But I actually have a question for David, which I don't know the answer to, and I talked about the fact that there's a lot of how we're aligned with what we do for people. So for what we do in personal injury cases, we have something under the law called spoliation of evidence. So where that if we know that they had video evidence in a store that would have shown our client's injury, and for whatever reason they claim to have lost the video evidence, if we can prove that they didn't follow their own protocols, then we can actually get an instruction from the judge that the jury can presume that that video evidence would have been favorable to us. Is there a similar circumstance under the law when police have these dash cams or body cams, and you know that they otherwise had it on them, but yet when it comes to prosecuting the case, all of a sudden they're unable to produce the video because they claim that it was lost or corrupted in some way? How does that work in a legal setting in terms of presumptions that the jury is supposed to make?
Well, there is supposed to be spoliation in the criminal realm too. I have yet to see it work. It seems as though the judges look at it like there needs to be some kind of, the defense has to prove some kind of intent on the part of the person to not keep the tapes. I've had a number of cases in which I've tried to bring that up, and it's kind of poo-pooed and gone nowhere.
And we did talk. We just talked about the spoliation of evidence. If somebody, it reminds me of talk about, the disclosure? Is that what you mentioned a little while ago? Or
Discovery.
Discovery, right. Yeah. Reminds me of my cousin Vinny when we're talking about that. That's my extent of my legal experience in criminal law. But certainly, after the break, I want to come back and I want to talk about, the system and what somebody faces and the odds that they face. So after the break, we're going to continue our conversation with David Zelis and Brandon Swartz. Thanks.